Thank you, Lascan Corla. Lascan Corla, we all know that we are in the middle of a serious homeless crisis. All of our efforts as a government and as an Oireachtas are being directed towards solutions that will help bring this crisis to an end. Fundamentally, supply must be and is being increased, thanks to the policies that this government is spearheading through Rebuilding Ireland. But as supply increases, we also have to ensure that we are protecting people who are currently struggling with housing affordability and security issues. And this places a particular focus on the need to continue to reform our rental sector. The rental sector in Ireland still needs to develop and mature in order to provide a viable, sustainable and attractive alternative to home ownership, rather than serving as a temporary refuge or a staging post on the route to home ownership. Our rental market is not like that of other European countries, not yet. It is true that we do not have a mature rental sector here in Ireland, and we are trying to transform it into one. But we do so at a time of undersupply, which makes it very challenging. And we do not have a cost rental market here in Ireland. In other countries, provision of cost rental accommodation comes in at 20 to 25%. And we are at the very early stages of building a cost rental sector here in Ireland. And if we get it right, the long-term benefits are obvious. And what we do have in Ireland is the Residential Tenancies Board, which provides strong protection to both tenants and to landlords. A professional landlord sector, similar to other European countries, is beginning to build in Ireland. But still, the majority of our landlords, 86%, own only one or two properties. Many are accidental landlords following the financial crash in this country, which is still having an impact today on housing, on banking, and on public and private debt levels. The makeup of our landlord sector, with its over-reliance on small and accidental landlords, has to be borne in mind. And we have to be careful in making changes to Irish tenancy law that these changes do not inadvertently cause an unsustainable exit of landlords from the rental sector. That would only make things worse. And recent data from the RTB tells us that landlords have left the market, over 1,700 since 2015. So this is a real and legitimate concern that all of us must keep in mind as we progress new reforms in the sector. We have to work with what we have and secure continued participation in the residential rental accommodation sector as we improve and reform it. Participation from the traditional landlord, yes, as well as participation from the larger institutional landlord, some of whom have only recently begun to participate in the sector here in Ireland. The Residential Tenancies Act was passed in 2004 and represented the most significant legislative reform in the private rented sector in over a century. And prior to 2004, the rental market operated in a crude and fragmented manner. There was little or no security of tenure for tenants, and recovery of possession presented a nightmare scenario of long and expensive court proceedings for landlords. Even minor disputes arising during the course of a tenancy had no avenue of resolution other than the courts. The combination of these factors resulted in the absence of secure, regulated rental market that could offer a real, attractive, longer-term housing solution to people searching for a home. Rented housing represented a tenured choice of last resort for many. It was perceived as being only for student housing, for bedsits, as a short-term solution, or indeed the only solution for those most marginalised and vulnerable in our society who couldn't afford anything better. This, thankfully, is not the private rented market of today. More people are renting now than ever before, and figures from the RTB show more than 339,000 tenancies registered from both private and approved housing body landlords at the end of 2017. And they are not renting solely because they cannot afford to buy a home, though I recognise that this is a challenge for many in Ireland today. Many people are renting because they prefer the flexibility that renting offers, because they do not want to take on the significant debt that is a mortgage, or the liability that home ownership can sometimes be. And it's also true to say that life is changing in Ireland, and has been for some time, resulting in people staying in education longer, marrying or committing to a partner later, or putting down family roots in a community at an older age than my generation's parents might have. And these factors too are lending to a growing demand for rental properties, different types of rental properties to the ones that we have seen before, and a better functioning and more secure and longer tenured rental sector. And not only in our rental policy have we sought to meet this demand, but also in the new planning and building guidelines that we have developed in the past 18 months around build-to-rent apartments, more cost-effective apartment delivery, and the introduction of new concepts like co-living. And these reforms too are now seeing an upsurge in planning applications for new apartments. And though for some renting has been a negative experience and hasn't meant a secure and safe home, for the vast majority renting works, and we need it to continue to work, but to work better than it has been, with greater transparency and accountability for tenant and for landlord. The Residential Tenancies Act of 2004 introduced real security of tenure for tenants in the private rented residential sector for the first time. It set out minimum obligations for landlords and tenants and provided access for both tenants and landlords to a cheap, informal and independent dispute resolution service. The Act laid out conditions for rent reviews and prohibited the charging of rents in excess of market levels. It set out fair procedures for the termination of tenancies and provided for notice periods linked to the duration of that tenancy. Under Rebuilding Ireland, rent caps in the form of rent pressure zones were introduced to limit what had up until then been very steep increases in rents, particularly in high demand areas. And what we have seen in these areas to date has been a moderation of rent inflation, particularly for existing tenancies, but rent inflation and rents themselves remain unacceptably high in many parts of the country. And people earning a good salary for a hard day's work are being pinned to their collar because their rent is too high.
Just a query, is there a copy?
Are there copies of your speech to be circulated?
It should have been provided by the office, but we were a little bit caught on the time.
Okay.
We were notified that we would be coming into the House a little later.
Okay.
So my office
just
hopefully
for the record, yeah.
doing
That's
that at the moment.
Okay. Thanks.
Thank you.
Thank you, Minister.
As I said last time, Corla, people earning a good salary for a hard day's work are being pinned to their collar because their rent is too high. This is also having an impact on their ability to save for a home. And that isn't the kind of quality of life that we want for our citizens. Others are having to make unacceptable sacrifices to meet the rent, or are sacrificing time with their families by making long commutes because they cannot meet the rent closer to where they work. Still others are living in overcrowded situations, or have to move back in with their parents at a time in their lives when they shouldn't have to. But those really suffering have found themselves without a home and are in emergency accommodation today. Too many. And that is the importance of the legislation that we have before us this evening. The bill that I am introducing in the House today, the Residential Tenancies Amendment No. 2 Bill of 2018, builds on what has been achieved by the Residential Tenancies Acts to date and by the Residential Tenancies Board and under the rent pressure zone legislation. The bill provides for the future development of the rental sector and with it stronger protections for our citizens who do not yet or may never own their own home. The bill centres on priority proposals in order to facilitate quick passage through the Oireachtas. It does not address everything that we need to do in the rental sector, and indeed a further rent reform bill will follow this one. But this bill contains those priority measures that we believe are necessary and must be enacted now, in the best interests of existing and future tenants. I do hope that colleagues in both houses will facilitate its quick passage. The bill delivers on a number of commitments flowing from Rebuilding Ireland and the commitments made in September of 2017 to provide the Residential Tenancies Board, the RTB, with additional powers and resources to deliver enhanced protections to both tenants and to landlords. The key measures and reforms are designed to enhance enforcement powers for the RTB, to provide greater security of tenure for tenants and further underpin the operation of the rent pressure zone or PZ arrangements, along with some further targeted priority measures. The bill is set out in 3 parts with 25 sections. I would now like to refer in some detail to the main provisions of the bill in those sections. Part 1, which is preliminary and general, contains standard provisions dealing with the title, collective citation and commencements of the bill. It also provides for definitions and interpretations of terms used in the bill and the Residential Tenancies Acts of 2004 to 2016. Part 2 of this bill amends the Residential Tenancies Act and provides for a number of key changes to the regulatory framework. Section 3 amends Section 19 of the Act of 2004 to provide a definition for substantial change in the nature of the accommodation provided under the tenancy, in respect of which an exemption applies from the rent increase limit of 4% per annum in RPZs, and to require a landlord to notify the RTB and to provide supporting information where an exemption to the application of the rent increase limit is claimed. In addition, Section 3, if enacted, will create 3 new offences, namely non-compliance with the rent increase limit provisions, knowingly or recklessly furnishing information to the RTB which is false or misleading in a material respect in a bid to claim an exemption from the rent limit, and non-compliance with the new requirement to notify the RTB of an exemption claim. Sections 5, 6 and 7 provide for technical amendments to ensure that various notice periods afforded under the Residential Tenancies Act, such as termination notices and rent review notices, are correctly applied. The amendment to Section 66 of the 2004 Act under Section 7 of the bill extends the notice periods that a landlord provides in the context of an impending tenancy termination. This is to tenants that have occupied a dwelling for more than 6 months and less than 5 years. And so for those tenants occupying a tenancy for 6 months or more but less than 1 year, the notice period, currently at 35 days, will increase to 90 days. For those of 1 year or more but less than 2 years, the notice period will increase from 42 days to 120 days. For those of 2 years or more but less than 3 years, 56 days to 120 days. And for those of 3 years or more but less than 4 years, the notice period will increase from 84 days to 120 days. And for those of 4 years or more but less than 5 years of a tenancy, the notice period will increase from 112 days to 120 days. And this provision aims to assist tenants by giving them extra time to reaccommodate themselves where a landlord needs to terminate a tenancy. And where a tenancy termination notice is determined to be invalid due to a defect contained in it or due to an error occurring during the service of the notice by the landlord, the RTB will be empowered to permit a landlord to remedy such a defect by issuing a remedial notice to the tenant, which provides at least a further 28 days on top of the original termination notice period. And significantly, the bill provides for a review of these new tenancy termination provisions during the third year of their operation. And I'll speak to some further intended amendments to the existing tenancy termination provisions later on. Sections 9 and 10 empower the RTB to charge a fee for its mediation services if it's deemed necessary in the future. Section 11 technically amends Section 123 of the Act of 2004 to make it mandatory for the Board to publish its determination orders and notices of cancellation thereof. Currently, the Board has the option whether or not to do so, to publish, and this amendment aims to enhance transparency in this area. A significant change to current practice will be made through Section 12 of the Bill. Tenancies will be required to register annually with the RTB. The aim is to more regularly gather accurate and detailed tenancy and rent data to inform rental market policy development and implementation. Currently, a tenancy might not require to be re-registered until the expiry of a 6-year period. This could occur where a tenant continues to reside in the same dwelling during that period. Section 14 introduces a technical amendment to provide a legal requirement at the address at which the landlord ordinarily resides and the address of the landlord's authorised agent are both supplied on the registration of a tenancy. Again, this is in the interest of transparency and the efficient operation of protections under the tenancy law. And as such, landlords will be obliged to supply their own address and not just that of their agent. Sections 15 and 16 provide for the RTB to charge fees for annual registrations of tenancies, including a €40 fee per tenancy registration by private providers and a €20 fee per tenancy registrations by an AHB, with fees increased by 50% for late tenancy registrations in line with the move to annual registration of tenancies. A registration fee can only be charged in respect of the same dwelling once a year. A discounted single registration fee can be applied where the same landlord registers not more than 10 tenancies of dwellings comprised in the same property, for example, up to 10 apartments in the same block. And the key change from the existing registration fee is that AHBs will be charged fees that are half of those applicable to private providers. Currently, all landlords pay the same registration fee, which is €90 per tenancy. The reduction in AHB fees is proposed in recognition of the public service that they provide in meeting the housing needs of those in receipt of social housing supports, their charitable or similar status, and the low incidence of AHBs requiring the services of the RTB, for example, its dispute resolution services. Section 17 empowers the RTB to pursue updates to its register from landlords with regard to rent alterations relating to tenancies in their dwelling. A new criminal offence is created with regard to non-compliance with the requirements to update rent information on the RTB register. Perhaps the most significant achievement of this bill, if enacted, will be the introduction of a sanctioning regime to provide for the carrying out of investigations of landlords by RTB authorised officers and the imposition of administrative sanctions by RTB appointed decision makers. Under the new Part 7A, the RTB will be empowered to cause of its own volition or on foot of a complaint an investigation to occur in respect of possible improper conduct on the part of a landlord with regard to complying with the requirements of the rent increase limit of 4% per annum in RPZs, including the new requirement to notify the RTB of a rent limit exemption claim, and the requirements to register a tenancy and to keep the rent details related to the tenancy updated with the RTB. In Section 18, provision has been made for the following: an administrative sanctioning regime for the RTB, appointment by the RTB of authorised officers and decision makers, and provision for their powers and functions, including powers of investigation, inspection and sanction for the RTB, power for the RTB to initiate an investigation without a complaint being made by the public. Subject to certain conditions, the RTB will be required to cause an investigation to be carried out upon receipt of a complaint of improper conduct by a landlord under the Act, oral hearings regarding matters under investigation, sanctions that take into account the nature of the improper conduct in question and comprise one or all of the following: a financial penalty of up to €15,000, payment of RTB investigation costs of up to €15,000, and a written caution, a right of appeal to the Circuit Court in respect of a sanction, and if no appeal occurs, requiring the Circuit Court to confirm all sanctions, and other ancillary matters in relation to procedures to be adopted by the RTB. And finally, Part 3 of the bill provides for the repeal of certain provisions contained within the Residential Tenancies Amendment Act of 2015 that have not come into operation and that have been overtaken by the provisions in this bill. I will also need to introduce last Ceann government amendments, including technical amendments to the bill itself and to the Act of 2004, as the bill makes its way through the legislative process in the Houses of the Oireachtas. I was keen to publish the bill as soon as possible to let everyone in the sector know that the government is serious in its intent to stamp out any improper conduct by landlords, particularly with regard to flouting the rent increase restrictions. I hope to introduce an amendment to allow the RTB to publish rental amounts in its register. This proposal is receiving due diligence by the Office of the Attorney-General. Enhanced rent transparency is our goal, and it is an important one. And specific amendments to better tailor the Act of 2004 to the operation of AHBs are under consideration, for example, in the context of impending cost rental accommodation provision by AHBs. Other significant proposed amendments to the bill are being worked on by my officials and by officials in the Department of Education and Skills and in the Office of the Attorney-General to possibly extend the application of certain provisions of the Residential Tenancies Act, particularly those connected to rent setting, to purpose-built student-specific accommodation let under licence by private providers or let under licensed tenancy by public providers. To be clear, purpose-built student-specific accommodation let under tenancy by private providers is already fully under the remit of the Residential Tenancies Acts. Also, any student who has signed a licence agreement with the private provider who wishes to raise a complaint or dispute with the RTP can currently do so. If the RTP find that the purported licence agreement is in fact a tenancy, they can go on to resolve the underlying dispute. As mentioned earlier, I also intend to examine the need to introduce further amendments to the existing tenancy termination provisions. My intention is for the existing grounds for tenancy termination by a landlord to be carefully examined by the Department and by the Office of the Attorney-General with a view to bringing forward any necessary amendments to legally tighten and enhance their operation on the ground and to empower greater enforcement of the provision by the RTB. The other areas that need urgent attention by my Department and the Office of the Attorney-General is the operation of the rent pressure zones in the short to medium term. I am sure that you are aware that my 3-year designation of the Dublin Local Authority area and that of Cork City will expire in December 2019 as rent pressure zones. An active consideration has been given to what amendments might need to be included in this bill to ensure that come 2020, tenants will not be hit with astronomical rent hikes. The opportunity is being taken to examine what other changes are needed to the operation of rent pressure zones and related exemptions. We will need to introduce amendments, and for now, I simply wish to flag that to the House and to the sector that these changes will be coming. Technical amendments in this area are being examined to ensure that it is fair in its application across the country and across the sector, and that tenants have reasonable rent certainty into the future. In addition to the changes being ushered in by this bill, the RTB is actively pursuing a range of modernisation initiatives. Arising from this Government's Action Plan for Housing and commitments made in September 2017 to provide the Residential Tenancies Board with additional powers and resources to deliver enhanced protections to both tenants and landlords, a Change Management Project Board has been established to implement and develop the Residential Tenancies Board multi-annual change management plan to progress a number of the proposals that were announced in September 2017. Demand for the RTP services has increased significantly due to the increasing size of the rental sector and also because of the changing regulatory structure. In 2017, the RTP received 5,823 new applications for dispute resolution services. This is the highest amount of applications the RTP has received in a given year. Almost half of all cases are processed and closed within 4 to 8 weeks. And dispute resolution services offer a resolution via mediation or adjudication and appeal process by a tribunal. The proposed new powers for the RTB are a crucial first step in expanding its overall role and function as part of a multi-annual change management programme to proactively enforce tenancy law within the rental sector. Additional powers and functions will be rolled out to the RTB as soon as possible, but in an orderly manner. And the change management plan will identify priorities together with the timeframes for their delivery, incorporating milestones along the delivery path. It is recognised that the RTP are not in a position to take on further additional work until the necessary funding and staffing can be provided. And so in Budget 2019, the budget for this year, it was provided for a 67% increase in exchequer funding to strengthen the powers of the Residential Tenancies Board and provide for greater local authority inspections in the sector. The Residential Tenancies Act Amendment No. 2 Bill of 2018 that we are discussing this evening, last Ceann represents a significant evolutionary step in the development of the residential tenant-landlord regulatory environment in this country. The introduction of a sanctioning regime for landlords who deliberately breach the RPZ provisions of the Act is an important step in the development of a wider regulatory framework for the residential rental sector in the coming years. This is a forward-looking bill that recognises the need for the broadening of its remit in order to ensure the good working of the private rented sector. Most of all, it will contribute to the continued development of the rented sector as an attractive long-term housing option and a crucial factor in the development of a sustainable housing policy as we continue on the road to economic recovery. I intend to build further on the published bill and the final enactment will represent true progress in the rental sector. And in doing so, and in making these reforms, Lascan Corla, we'll be able to help those people who are struggling today, not just to meet the rent, but those who cannot meet the rent and find themselves in emergency accommodation this evening. And I commend this bill to the House.